doesn't know, I am the founding partner of Brown Dutton and Kreider in Marietta, Georgia, and I am doing a series breaking down the differences in family law laws from state to state. And with me today, I have Frank, and he is an attorney, a family law attorney in North Carolina. So, Frank, can you introduce yourself and your firm?
Yeah, I'm Frank McFarland. I'm one of the partners at King Law in North and South Carolina, but I'm only licensed in North Carolina where I practice mostly family law. And
Awesome. Thanks. It's crazy how different the laws are from state to state, I have learned.
one of the places that I pick up on that the most has been TikTok, doing live videos and getting questions and stuff. You're like, gosh, that just does not sound anything like, anything we would deal with in North Carolina. So,
I know,
yeah.
and I think it seems to be mostly in family law, but it's so drastically different from one state to another. But what I find is, I think a huge difference is fathers' rights. So let's get into that first. Let's say that a man and a woman have a baby in North Carolina, and first say the dad's not on the birth certificate. What
Okay.
rights does he have, if any? And if he was on the birth certificate, does that make any difference in North Carolina?
And I mean the easiest answer at that first place, let's say they just have the baby and he's not on the birth certificate. The easiest answer is probably none. There are some exceptions to that, but in terms of what third parties would recognize, it's basically none. You know, I There is sort of a debate on whether or not you could file for custody just on being dad alone. We do it all the time. So the answer is mostly yes. But at the same time, that is also a debated topic. So really, even to the point of with the court system, whether you could even do some of those things, you may have to do a legitimation or establish paternity first.
So that leads us into a good question. So, does North Carolina require a legitimation for a dad of a child born out of wedlock to have any rights?
Yeah, there's really a couple ways. There is an affidavit of parentage that can be done too, but in general, what we're talking about is, can you do this on your own? If the other side, if mom agrees to this, then it may be a little bit easier in some situations, but you're also, on the hook for, basically at that point, you are establishing that you are the parent for support purposes and for, whatever those benefits might be, but legitimation still may be necessary. It all circles back to the same place. And I think there's a lot of what a birth certificate establishes or doesn't establish um, is another kind of question that would depend on who you ask, what answer you might get.
Hmm.
All of these things basically lead to a change in the birth certificate. So,
Right.
even if you go through a legitimation, it's sent off to vital records, it comes back, you get a new birth certificate. That's what you would show the third parties. You wouldn't take your legitimation order to the school or, whatever. So I think it comes back to the birth certificate, and I think that would establish a lot of those. But you would also hear people telling you that it doesn't, conclusively establish those rights then either. So maybe legitimation would be necessary, even
What
if you're on the
do
birth certificate.
does a dad have to, well, let's say that the parties have a kid together and dad is on the birth certificate and mom starts denying him access to the child. What would he have to do in North Carolina to establish a parenting time plan or a structure for that child?
You're going to have to file
Yeah.
at that point, and that's that would be married couples, not married, whatever it is. In North Carolina, you basically have an equal right to physical custody. Now, it's different. There's a presumption towards joint legal custody prior to an order being entered. So you can push back on some of those actions. Some of those decisions that were made can, in theory, be held against one parent or the other that refuses to allow that visitation. And sometimes they do, but you're going to have to file for custody in North Carolina to establish any sort of schedule, because it's an equal right that can't be infringed upon, basically. So each parent has that equal right to physical custody. It'd be the same way if dad is on the birth
Right.
certificate and has their rights established. If they say, I'm not giving the kid back, I'm not going to do this handoff, whatever that might look like. It's the same way. There's nothing that mom, the police are not going to come take them. There's not really anything that can be done outside of filing in that scenario.
See, and that's what's actually completely opposite with Georgia law. So if the dad's on the birth certificate and the parties are not married and he does not have a parenting plan, he has no physical rights to that child or legal rights to the child in Georgia until he files a legitimation and has an order. So if a dad was, and he's on the birth certificate, he's keeping the child away from the mother and he hasn't filed a legitimation, then he has no rights to that child. He has to
Well,
establish that through the court.
yeah, it would be the same way in North Carolina, basically, with the exception of what the birth certificate is that sort of gray area. If he's
Yeah.
on the birth certificate, then, I think at that point, everybody is going to assume that these rights are established, even if they're not. Some situations they may not be. But yeah, it'd be the same way in North Carolina. You're going to have to go to court first. Now, you could just file in North Carolina. I don't know if it'd be the same way in Georgia, but you could just straight file for custody here.
Mhm.
Whether you would want to do the legitimation too or not is a different question. There would be reasons to do it and reasons not to, and you can also file a civil action for paternity in some situations too. So there are a few other tools that you could use to get there, but yeah, it's basically the same way.
Yeah. And what I tell people here is I'm like, you don't have to wait to do a parenting plan until you are at odds with each other. You can do a parenting plan when y'all get along great. And that's actually better for everybody because then in those situations where you don't agree on what you're supposed to do with the kids, you've already got an outline of expectations. And at the end of the day, it's better for everyone.
Yeah, I couldn't agree more with that part. And it look, in North Carolina, you're going to have to file a lawsuit, so you have to serve them with a complaint for custody. And that is something that is always going to trigger these, very emotional reaction. You just sued
Yeah.
me. Our standard language in those complaints is going to be ask for everything, even though that's really not what the goal is. And, that's a part that I think is worth some discussion between attorneys even. But if you don't file for it here, basically you could never get it no matter what kind of happens from there. At least that would be the theory behind it. But we would ask for everything, and then they get hit with it, and it's, oh no, no, I'm not agreeing. I'm not going to work
Yeah.
with you on this. You're taking me to court. We do that sometimes by sending a consent order with it.
Yeah.
Here's our friendly complaint. Here's our agreement that we would offer to. So there's some ways that you can work around, and sometimes we've even worked it out beforehand, walked it over to the courthouse to file, serve it, then have the consent order signed, at that
Yeah.
point. But having a
Yeah,
court
and
order
you
is
can do it
important
to,
too.
and you can give
Yeah,
them a heads up too, especially if you're
right.
on, if you're in a good situation of saying, hey, I'm gonna do this. It protects our kids, interest and rights and both of ours moving forward. And so it doesn't always have to be a knockdown drag out. Can can a father be put on child support in North Carolina without having a custody schedule, or are they always connected?
Yeah, absolutely. They can be put on child support without a custody schedule. So that one's easy enough. It's probably more debatable whether they could be put on a child support order or obligation without having their parental rights established. There's
Mhm.
going to have to be something establishing paternity, in a
Right.
child support case. But even that can sometimes be a little bit different because there's no legitimation. If the legitimation is where they get those rights, it's not really, it's more of a practical or it's not a practical debate. I don't think for the most part you're going to have those rights if you're having to pay child support. But with that equal right, in terms of physical custody too, mom, dad, whoever may be giving zero time to the other party, and they could still be obligated. And in fact, they would have to pay more.
Right.
Overnights is the main thing that we go on. In terms of determining what the child support amount is overnights and income. So if they're doing that, they may get more child support than they would if there was a custody order in place.
Right. If they actually had established time with a
Right.
child where, yeah, it was guaranteed. So, what is in North Carolina? Is there a default for 50-50 custody. Here in Georgia, we have it's a best interest standard. And so the judges
Yeah.
do not start at a 50-50 and go from there. But what about North Carolina?
Yeah, there's no, it's best interest here too. Now, there is some statutory language, and then, there's been some court decisions that have expanded on this some, where it basically, the answer to that question is that the court has to consider joint if it's proposed, but there's no even definition of what joint is. And I talk about, this is one of the biggest topics that I've done in videos and lives and everything else. People get so caught up in North Carolina in the terminology, and there's really no legal, it's really not even a term of art. Joint custody, even in North Carolina, is really, there's not a definition put behind it. So what that looks like is not, everybody assumes that's 50-50, and for child support purposes it could have meaning, but it's the schedule itself and the number of overnights. So um, it's always going to be, it's going to be best interest. I think that our courts do consider it a little bit of a presumption towards 50-50, but I think they move away from it very quickly if there's any facts that would, support one way or the other.
Right. We've got a handful of questions, and I'm gonna and we'll answer
Yeah.
those, and then I've got some other ones too. The first is in Georgia, do you have to pay child support for 50-50 custody? And usually, yes. The way that our child support worksheet works is it's a combined household schedule, and so the party who makes more still pays child support to the other in a 50-50 custody. Now, we have the ability to consent and to deviate that child support, but if it goes to court, the party that makes more is still going to pay child support in a 50-50 schedule. What about in North Carolina?
Yeah, it's the same way. 50-50, we really have two different worksheets, and it's based on the number of overnights. One is more of a joint physical schedule, and it's still, if one party's making more money, then they're probably going to have, a child support obligation with it too.
Let's see. Someone asked what part of Georgia I'm in. I'm right outside Atlanta. We practice all around the metro Atlanta counties. Let's see. What about expenses for kids? And what is in North Carolina? What's typically inside the worksheet, which would be like included in child support? And what does the judge or court typically do outside of the worksheet that the parties would, split or pay pro rata? What's typical?
Well, it really doesn't factor, it probably doesn't factor expenses enough in our worksheet. I mean, really, the when we start talking about child support, it really is just the income, and then, where there should be a deviation is really what it comes down to. And it's going to be fairly rare. There are some expenses that are going to come into play. We call those extraordinary expenses. Um, and it's difficult to define exactly what they are, but I think, you really think true necessities that are out there. Almost always it's going to be half of uninsured medicals. So,
Hmm.
you'll have that factored in automatically, but then everything else, it's kind of, it's a little more subjective in terms of what that looks like with, the Court of Appeals kind of defining some of what that is and isn't. But
Yeah. What about extracurricular activities?
most of them will not be covered. There are, like I said, there's probably, I've made arguments on a bunch of extracurriculars that have not worked out for me too well, but there are some that occasionally will. Um, I would think something linked to their health more than anything, something linked like maybe schooling that they're really, really struggling and they have to have this, but the baseball team, whatever, it's rare that the court would include it. Now, I think a lot of times that you'll find a lot of orders that do address those issues, but if you had a trial on it, it would be pretty rare.
Okay. Yeah, here in Georgia, the big ticket items that are looked at usually outside the child support worksheet are like what you said, out of pocket, uncovered medical expenses,
Right.
um, extracurricular. So our worksheet anticipates 7% of whatever the child support order is to go towards extracurricular activities. But a lot of the times the judges will either, depending on what the child has historically done, will order that the parties also split that or pay that pro rata, or the parties will just agree to that. And then work-related childcare will go in the worksheet or out of the
Yeah, that
worksheet,
would definitely
depending
be
on
in
the
there in ours
case.
too. Yeah.
Yeah, so if you've got daycare and that's a big expense, or any other work-related childcare. Let's transition to divorce. So in North Carolina, do you have fault-based divorces, or is it all no fault?
No, it's all no fault. The divorce itself, at least, is all no fault. Really, the only thing that we consider fault for the most part in is going to be alimony. Everything else is pretty much date of marriage, date of separation, or really just date of separation and whether there was a year separation or not.
So how does that work? Because here in Georgia, we've got 13 grounds. So you can still file for divorce on the basis of adultery or habitual drunkenness or cruel treatment. But most people file irretrievably broken. But how does an affair or adultery, how would that affect a divorce, if at all, in North Carolina?
Only in alimony. And that's really hard for people to accept in a lot of situations. They want to bring up a lot of fault grounds there. But for the most part, whether you can get a divorce or not is really the only question that the court asks is whether you've been separated for a year or not.
Yeah, alimony, and we've got a question about best interest standards, but when we'll come back to that. But alimony here in Georgia can be affected by adultery as well. How it works here is it's a bar to alimony. So if, say, I'm married to someone and I am financially dependent on them. If I have an affair and my affair is what leads to the breakdown of our marriage, then I am statutorily barred from receiving
Yeah.
alimony from that person. Um, it also can come, behavior can come into effect in Georgia, on equitable division. So if someone's behavior resulted in a liquidation of their marital assets or something like that,
Yeah.
then the judge can consider that in deciding what each party receives.
Yeah, that's pretty much how I tell people to draw the line. The fault grounds in alimony, all marital misconduct is relevant, but it can be bars. Like, it sounds pretty similar to the way you described the Georgia law on that part. You could even have a situation where if you were the dependent spouse and you were cheated on, you could even have this presumption of alimony in some situations. There's some other factors that would go into it, but it can almost be automatic in some of those. Now, not the amount and the length, and it ends up being a very, still the same test that you would do otherwise. But marital misconduct factors in. But in property, it really has to tie to the money. If we tie it to the money somehow, then it could have an impact on property division. I kind of like if I was doing a consult, I'd probably say, if they're having an affair and they're, staying at a nice hotel every Friday night, then that's going to have some bearing on, the financial side. If it
Right.
is that they're, hiding money away and they're doing, whatever, just you have to tie it back in to the financial side. There's a list of factors that are considered, but for the most part, that's kind of where it is. Is there a money tie somewhere?
Yeah, and that's really what our court comes back down to as well. We've got a few questions about the best interest standard and whether the best interest standard is unconstitutional. And I mean, my position would be obviously that it's not. It's what every single case is based off of in Georgia, which many cases have gone up to the Georgia Supreme Court, where the lower court has been affirmed in applying that best interest standard and what discretion the judge has on that. This particular user quoted two sites that I am not familiar with. I'm interested in
Yeah.
reading them, but I would say it certainly is constitutional and it's in fact enforced in most of the states across the US. Do you have any additional feedback on that?
Well, here's what I would say, and then, it never fails on these parts, the constitutional arguments on child support and best interest and some of these other parts. I'm also not familiar with these cases. I'd be happy to look into it. The problem is where in the Constitution, the constitutional part of it is that it belongs to the state. There's definitely nothing in there that says here's where custody, here's the line for custody in the Constitution. So if it's not in there, then the state's going to get to decide. And that's where we deal with. I think people go down the wrong road. I think family law reform is a big, big thing that should be focused on, and we should do everything we can to make it better. But at the end of the day, making these arguments is probably not helping you get your kid back, or you have a better situation for, your custody case or whatever. But you can go to your legislator and have these arguments about what the statute should read, and maybe I think defining out more what best interest should be is a pretty good topic. I think that adding some lines in there about certain things, I think there could be some usefulness in that, and definitely some usefulness in reform. But at the end of the day,
I think there's, yeah. And I think there's major issues with areas of family law of,
right?
you know, still there is problems with false allegations in family law that aren't really completely vetted. There's lots of problems in our area of law that the legislatures are, are working to fix, but obviously they need the involvement of people that are dealing with the issues. We have, can you still get a prenup even though you bring someone from Europe? You here in Georgia, yes, we give full faith and credit to prenuptial agreements that are either done in our state, in our country, or out. They just have to meet the test that we apply here in Georgia, which is essentially full disclosure and no duress, and that it's not unconscionably entered and not so unfair that it could be found unconscionable. So we certainly would abide by a prenup that was entered if someone was coming from Europe. What about North Carolina?
Yeah, it's going to be the same. I mean, as long as the requirements are met, for North Carolina law, then it's going to be recognized. I mean, and full faith and credit is a perfect example on how that could work in a lot of different areas. But if you were doing this to establish it, meaning if you don't have one yet, um, wherever you're at is probably where you're going to want to have that drafted out at the time. If you think you're going to be moving soon, you may should consider, looking into that in other places too, whatever would work the easiest for you. But yeah, that there's no reason that you couldn't. It doesn't. There's no provision that says, well, just because your spouse to be is from another country, that's not going to bar you from being able to do a prenup in North Carolina in any way.
Right. I think people overly complicate the idea of prenups. All it is a contract, right? And
Right.
you're making sure that you're meeting the requirements of whatever the contract is. There's certain things you can't contract, right? You can't contract custody of a child that's not born because the best interest standard. And so, but when it comes to your finances, when it comes to alimony and division and all of that, you can decide that before you ever get married.
Absolutely. More people should too, really. But
They really should. I mean, I completely agree. And I think a lot of people think, well, if you do a prenup, you're expecting a divorce. And I'm like, that's not the case at all. You're actually protecting your family in the event that that does occur. And it really reduces the amount of friction and the amount of um, drama and money that you have to spend going through a divorce if y'all already know what that looks like ahead of time.
yeah, exactly. I agree with that completely. And you don't have to be the rich, billionaire to need a prenup.
No.
But like, if there are topics that would be complicated, you know, I wouldn't get married if you're preparing for divorce either. But at the same time, you may have some red flag type issues, whatever those might be. Maybe there's a family member of the person you're marrying, and maybe it's a kid, or whatever it might be that would make you a little more nervous about how things would look, and if you have a business, or like just the more complicated things we see in divorce. You know, if you can deal with that on the front end, why not? Why
Yeah.
not when everybody's cool headed and not, not mad about whatever just happened that led to your divorce.
Exactly. Okay, I've got two more questions. The first is from a viewer. It says, I voluntarily terminated my parental rights out of fear and threat, and this was in Illinois. Can I get it overturned? Well, obviously, we cannot give legal advice on this app. This is just for informational purposes only. But if any rights were terminated in Georgia, then that is final. Unless it's subject to an appeal and the appellate court is obviously deciding on those rights. But once rights are terminated, that is final here in the state of Georgia, at least.
Yeah, there would be some limited exceptions, but I would almost say that it's almost non-existent when we basically would have to overturn the order itself.
Right.
So, I mean, an appeal would be an obvious example, but then, there may even be some other situations, new facts or whatever that may come to light that would change that some. But I'll tell you one of the things that I noticed, and this is another good example of how different state to state might be. You really can't voluntarily terminate your rights in North Carolina. There's not, I have people that come to me occasionally like, hey, I want to terminate my rights. Can't really do that in North Carolina.
Hmm.
There's not a process. I can't file on behalf of you to terminate your own rights. If a petition was brought, you really can't consent either. Um, Adoption is the lone exception to that. And then, if you go through DSS court, there's a relinquishment. But all those things, at least in terms of the true termination, that's where it lands.
Yeah, and that's very similar here. I mean, I've had one case in 13 years where the mom had petitioned to terminate a father's rights that were already established, and the dad consented, and the court granted it without an adoption. And it was a extremely unique situation. It took about a year and a half for the court to actually grant it. But in general, the courts are not going to terminate a parent's right until an adoption is in place because the state really has an interest in having two parents having a
Right.
responsibility for a child. So it's very, very rare that that would happen without having a second one. So my last question is relocation. So let's say that there's a custody order in North Carolina. It could be from a divorce or a legitimation, paternity action, whatever it may be. But there's an order in North Carolina. How does relocation work? Does the moving parent just have to give notice? Does the court have to approve that relocation? What is the law for relocating parents?
It's going to depend a lot on the order language. Assuming there is an order, if there's not, completely different issue, and it can be an emergency custody order could be granted here if you were to leave the state. But the order language is going to carry a lot of what you should or should not do in that scenario. There are a lot of times where you could still follow the language of the order with a move. But almost all the time, if a judge does the order, then they're going to include some language about relocation. And when they do, um, I give some different advice. Sometimes it depends on the scenario, is the
Hmm.
honest answer. You know, if you could give the other party notice, I think you should give the other party notice if it's included in the order. But there are times, and you shouldn't, I'm not advising ever anybody to violate the order, but there may be a let's move and then file, or there may be a let's file and then get them to approve the move. I think really the way that you look at that depends some on the factual, on the facts of that specific case, because sometimes it may be better to do it because this is a necessity, and then court, what are you going to do with it? And then as opposed to saying, court, will you sanction this move? And in that situation, I just think the courts are way more likely to keep somebody where they are in that scenario. So it really just depends on how much of a certainty this is, or
Yeah.
why. If it
Right.
is
And
a very desperate
sometimes,
situation.
yeah, and sometimes you have to
Yeah,
file to stop the move, right? To make sure that your kids
exactly.
aren't
Right.
relocated. So
Right.
it's a very, the advice would probably be very different based off the um, actual relocation and what you have to do to ensure that doesn't happen. Because here in Georgia, we've got a statutory requirement to provide notice, but it's the other party that has to initiate the modification if they're objecting to the move. And so the purpose of that is to give a time period for them to
Right.
get that modification filed if you don't want the move. And in general, the judges, you're going to need a good excuse to move. If it's just,
Right.
hey, I met a boyfriend in Texas and I want to go move, that's not going to fly well with the court because the court's going to really want to keep the relationship, if at all possible, with both parents.
Right. Yeah, well, and not just that, but all of the things that the child has in place where they are.
Right.
Anytime a move happens, there's going to be all those factors that go into it.
Yeah,
And
it's a major
that's
change
very,
for them.
yeah, that's interesting. I mean, we don't, North Carolina, I'm sure Georgia's a little bit of the same way of this. What happens in Charlotte or Asheville or Raleigh is going to be very different than what happens in the smaller counties that surrounds them.
Hmm.
So even the way that everything is looked at, I've been lucky enough to practice in most of the counties kind of west of Charlotte, and there's so many different explanations that you're going to get. There's so many different courts that are going to say, some are going to be like, no big deal, and some are going to be like, this has to happen today. You got to get back here and bring the kid, or I'm holding you in contempt until X, whatever. It's just so different how you're going to get the responses, county to county, judge to judge, and I'm sure a lot of our really the more southern states for sure. I'm guessing deal with that a lot, but
Yeah.
it's interesting to hear how Georgia deals with that because North Carolina is not that formal on it, even though the order language a lot of times will be, which then kind of you know requires it out of the contempt powers.
Yeah, and I always tell people it's so important that your attorney is familiar with the county that you're in. And, some, if not all of the judges, because even our office is in Cobb County and we have like 10 attorneys or 10 judges, even one judge to the other could give you such drastic
Yeah.
differences. So it's really important that the attorney that you're going to is familiar with the county that your case is in, and here in Georgia at least.
Yeah, absolutely. And I know it's not really a part of this question, but one of the biggest things that I try to do, I feel like my biggest job is preparing people for what's going to happen. We
Yes.
have some level of control over the result, and I'm not going to say that there are not good attorneys, bad attorneys, certain people who are going to get better results with certain facts, whatever. Those things happen. But for the most part, if I know what a judge is going to do and I know what's important to that judge or that court, then that becomes a much bigger factor than how well we may argue our case because you've done the things already to prepare yourself for that for that hearing and for what the court is looking for wherever you are. And obviously that changes. You may have a judge that's sick on your trial day or whatever.
Yes.
There's just other things that you can't control. But at the end of the day, like I want to predict as well as possible what's going to happen in a case with my clients, and that range may be wide, but at least they know the lines.
Yes. Yeah, definitely. And part of what we do, and I tell this all the time, is tell clients all the time, my job isn't to tell you what you want to hear. My job is to give you a realistic expectation because the last thing I want is to promise you something and we go into a courtroom and that doesn't happen, right? Then you've wasted your time, your money, to go into a situation, and we can't tell the future. We're not always going to be right. But if you're familiar with your county and with your judges, you can give a pretty realistic expectation on the outcome of a situation for people.
Yeah, and really more than that, it's preparing them for the worst. It's at least keeping that part in mind, so then that's not, there's no sticker shock from that. And then I think you can almost always get better results if that's where your focus is, because you know, this is how we avoid that, and get you to where you really need to be in a case.
Yeah. Well, I love learning about the different states and how their laws differ from ours. And I really appreciate your time today. If anybody has any other questions, they can email either of us directly. But again, we can't provide legal advice over this platform. It's just general information only. But Frank, I really appreciate your time today, and it was great talking to you.
Yeah, I really enjoyed it too. So definitely appreciate what you're doing here, and a lot of information out there for people. And TikTok pages like yours are a great resource for that too. So I appreciate you having me. And if anybody has any North Carolina questions, feel free to check out my page, and try to give as much information as I can on there with the lines that you have described. Obviously on the legal advice side, which gets tricky. I know everybody wants their answers,
It does.
but in general, it's, hey, what about this very general video that we just did last week on this
Yes.
topic?
Yeah, exactly. I think we do the best we can with the audiences we have and try to direct them at least in the right spot.